The History Department and the faculty are completely delighted to have as our guest speaker today my former student, Brian Mathias. And Brian, of course, as you've read, is a lawyer, and he is also a fellow, a constitutional law fellow at the Monterey School of Law. And this gives us an opportunity to remind all of you undergraduates that if you've worked with a professor, even a few classes, make sure that you visit us in the office hours, make sure you talk to us after class, make sure that after you graduate, we love to hear from you. Brian did all of those things along with taking my classes, and I was very pleased several years ago to find out that he had been successful in getting a law degree and is now a practicing lawyer in the area that he grew up in, which is an enormous accomplishment, as all of you Californians know, given how difficult it is for you to stay in these places. I would have remembered Brian's work anyway, though. Even though he graduated a decade ago, Brian took 5 classes with me, and he did his senior capstone course and wrote a paper, a very fine paper, already anticipating, it really hadn't hit the undergraduate level yet, on globalization. Brian had worked in my course on modern Italian culture and he came up with this topic all by himself, on Albanians in Italy. And at that time, I only really knew about that because when I would walk down the streets of Italy, I would see, lots of Albanians and their struggles and traumas there. But Brian did he pinpointed this topic quite prophetically, I would say. So I'm very happy to introduce Brian. Thank you.
So has anybody been asked as a history major, what are you going to do with that? And what do they say? You're going to teach? Are you going to become a teacher? That's what I was always asked. And I knew I didn't want to be a teacher, but I didn't necessarily have an idea of what exactly I wanted to do either. But it is a good question. History, what is it good for? A history major, what do you do with it? Well, here's what I did. I went to law school, and now I practice law and use history every day. It's the basis of what I do is reconstructing history. And so today I'm going to walk you through a real case and how I reconstructed history with a group of other lawyers, of course, to help a real person. And we have the remote. So here are the facts. Just like history, like if you were going to study Italian history, you would know some basic facts before you dive into a really narrow topic like Albanians in Italy. You would know, well, Italy, they speak Italian. It's a peninsula. It was founded by a Caesar, and there was a line of emperors and a long history, and you know these basic facts. So imagine a client, you're a lawyer, he calls your office, he's 60 years old. He doesn't speak English very well. He was abruptly fired on June 14th, 2012 from his job after 25 years as a maintenance man. So he does a physical, blue-collar type of job. Allegedly, he's fired because they said his back was too injured. He couldn't lift heavy objects, so his back is injured. Allegedly a problem lifting, and he couldn't climb ladders. So that's why they said he fired him. So pretty specific reasons. But he says he was performing his job just fine until the day he was fired, and he worked there 25 years. And now he's in danger of losing his home because he had a job, and all of a sudden he doesn't. So he wants you to work his case and represent him in a wrongful termination case. So how are you going to help this man? Here's the legal context. Disability discrimination. It's illegal in California and federally. And the crux is this, without getting into the details, and there's lots. It's illegal to terminate an employee because of their health condition, including something with your back, if the employee can still perform the essential functions of their job with a reasonable accommodation. So if they can alter the workplace in a certain way and still keep a person working, it's illegal to fire a person like that. And another point, you can't terminate a disabled employee until after a transparent investigation and discussion of all the facts called the interactive process. And behind all this, the employer can't rush to judgment. So that's the basic law. This maybe doesn't have to do with history exactly, but this is the world that we're in. So you need to reconstruct history to prove this man's case. Was there disability discrimination? There was something with his back. They said he was working and then he wasn't all of a sudden. That sounds pretty weird. So how do you prove this man's case? Again, you must reconstruct history. This is what many attorneys do all the time, whether they know it or not. And whether they know it or not, including me sometimes, you're going to be using the historical method of using evidence, just like you do in history, in collecting data about a certain point that you're interested in or studying to establish a fact and prove it. There's different types of evidence, just like there's different types of history, like oral history or written history or archaeology. There's testimonial type evidence, and what are called depositions. That's a compelled, basically a compelled conversation or interview under oath. And then there's written statements where someone will sign something, I swear under penalty of perjury that the foregoing is true and correct, throw me in jail if this is false, blah, 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 call it a declaration. And so that's one way to prove your case, reestablish history, a declaration. You have documentary evidence, just like you have all these texts for European history about anything under the sun, even if it's just a fragment of one document, you can still glean information about that. So you have documentary evidence, medical reports, performance reviews. What did the performance review say about this guy that was fired? Did it say he was working safely? Did it say he was doing a bad job? Did the medical reports say he had any prohibitions from working? Did his doctors allow him to work? What did those things say? What did his coworkers say? What do they say about the history of this legal case? You can find out. There's tools to do that in the law, just as you have tools as a historian in books, in treaties, in archaeology, and all those mechanisms to see what happened. And also oral histories, the stories people pass down and the things they say. But just like history, all that evidence is given a certain weight. It's not all given the same amount of importance. For example, if something is hearsay evidence, meaning it's merely a statement that was repeated by another person and then it's presented as the truth, then that's probably less credible than the person who actually said it, coming into court and saying it aloud. You have to examine motives and bias, and whether it's a primary or a secondary source. For example, are you basing your study of Albanians in Italy based off of a journal of an Albanian immigrant, or is it based off of a large study that was already done by another scholar and it's in bookstores everywhere? That's probably a secondary source. You're not going back to the primary piece of evidence. It's subject already to someone's interpretations and beliefs about what happened. So that's live and well in the law, and judges, whether they know that or not, and juries are going to be examining that and be giving it certain weight. So the first exhibit, and this is a real-life document, which has been heavily redacted to protect everyone's privacy. It's the immediate supervisor's declaration. So this man worked in an Acme company, and he was lower on the totem pole at Acme, but there's people above him. There's an immediate supervisor, there's a supervisor above that, and then there's management, the people who fired him, and I call them the terminators. So, this is what the immediate supervisor said under penalty of perjury. Again, it's a written declaration, and it's been heavily redacted. So, so to my knowledge, I'll call him Johnny, plaintiff, Mr. Plaintiff, performed all his essential job duties while he was my employee. So going back to the legal world that they're in, where you're asking, well, could he perform the essential functions of their job? And the immediate supervisor says he could perform the essential functions of his job. That's pretty good. That's coming from the immediate supervisor. That's pretty credible stuff. The guy who's maybe watching him every day, writing, his performance reviews, issuing his paychecks, seeing him working side by side on occasion. That's pretty powerful evidence to reconstruct your history. He goes on to say that Johnny never expressed to me that he was outright restricted or banned from using ladders. So again, remember our guy, Johnny, was terminated allegedly because he couldn't climb ladders. But Mr. Supervisor says there's never a problem. He never said he couldn't climb ladders. So what's going on? You're pretty curious as a historian at this point to see what's going on with the history. What happened? Now you have this employee who says they can climb ladders, and you have an immediate supervisor who wasn't involved in the termination of this man saying, yeah, you could climb ladders. What's happening? You better keep digging. Something's happened in history that you don't know. And then you go on at the very end, and it says, I had no idea that Johnny's job was in jeopardy at any time during my employment, nor that anyone in management perceived that there was a problem with Johnny's performance. So all of a sudden, just like this man approaches you in your office and says, I was abruptly terminated, I have no idea what was going on, I was working there, and then they said, I'm done, I'm fired, I'm on kick to the curb. This guy says the same thing. He says, I was the guy's supervisor, what happened to my good employee? Right? This is pretty good stuff. It's a declaration, sure, maybe not as credible, because it's just a piece of paper. You're not talking to Mr. Supervisor himself and having him present this information in court. So you can see the immediate supervisor's declaration, your evidence. He performed all the essential functions of his job. Remember, that's kind of the legal point you're trying to prove, just like you're trying to maybe establish or even disprove yourself on a certain way in history. You're trying to establish he could perform the essential functions of his job. You're an advocate. The supervisor never heard about an issue with ladders. That's pretty important. The supervisor never even knew his job was in jeopardy. And remember this interactive process thing where they have to discuss what's going on, what happened. They have to talk and communicate and exchange ideas about, can you really do this job with or without a reasonable accommodation? Well, it sounds like the immediate supervisor wasn't contacted at all. Is it credible? Well, you learn that the supervisor's a longtime former employee who's now retired. He's not going to be in fear of retaliation because he still works there. And in the alternative, he retired. He wasn't terminated for stealing or terminated for coming in tardy or something like that. He was a good employee. So how can Acme Co. turn around and now say, well, this supervisor, you can't believe him because, and all these reasons. It's looking like this guy is pretty credible. And he worked with your client, Johnny, the plaintiff, for a decade, long time. And again, he's his immediate supervisor. They're working together a lot. He has a lot of ability to perceive, and he's a percipient witness to what's going on. This is equivalent to maybe a primary type document when you're reconstructing history as a historian. So again, you want to keep digging to prove your case, to reconstruct history. Could this guy do his job that involved ladders? What was his medical condition? He was fired because allegedly he was too sick to work. He was too injured to work. That's illegal perhaps, so we got to keep digging. What did the doctor say under oath at deposition? This isn't a piece of paper now. This is a live person talking to you after swearing to tell the truth under penalty of perjury, with a court reporter typing every word that's said and opposing counsel with an opportunity to cross-examine him after you're done, to really dig in and see if there's another thing he's hiding. So what did Johnny's doctor have to say about this ladder issue? So you can see on lines 11 to 13, where I ask Johnny's doctor, did you specifically tell Johnny that he could not use ladders? His answer, no. Okay, that's pretty important, and you have to admit before this, I didn't know what the doctor was going to say, so it's like, what is he going to say? No, oh, awesome. You keep going, keep your cool, but that's pretty good. That's, again, even more credible than the actual supervisor's written declaration. This is a man who just said this to your face after swearing under penalty of perjury, and the other attorney for Acme Company is sitting right there and also has the opportunity to dig in, ask questions, cross-examine him, and see if there's something more to that no answer that he didn't tell you. So from the doctor's deposition, Exhibit B, your evidence. Well, sure, he was prescribed this medication, but he never put a ladder restriction on the plaintiff. And that's tracking closely with, number one, what Johnny, the employee, said And what the supervisor said, that there wasn't this issue with ladders. Is the doctor credible? Well, he's the plaintiff's treating doctor. He's not, he's also, like the supervisor, seen and dealt with and spoken with Johnny, the plaintiff. He's a percipient witness, just like someone who maybe documented a historical event themselves after seeing it. That is given a lot of weight in history. He prescribed this drug, maybe, you know, that led someone to believe that he couldn't climb ladders, but he's, again, his active treating doctor. And frankly, number three, the third point, this guy, he's a doctor, an MD. He's highly trained, highly educated, and he's articulate. He's a professional. That's given a lot of weight in history when people like that write stuff, and it just is. And it's the same way in the court system when you're proving your case. If someone comes across as believable and credible, and they're highly trained, highly educated, and they're talking about something that they're educated and trained in, that's pretty good. Just like you would in history if you have a perhaps throughout the centuries, there's been many heresies that have popped up across Europe. But if you are reading a Catholic bishop's view of those heresies, it's probably not as accurate in what one of those heretics would actually say. Like, for example, the Albigensian Crusade in France, it's probably more fair to hear what they had to say about their religion themselves as compared to the Catholics who were opposing them and prosecuting them and actually going to war. So you hear what the people actually who created this history are saying about it. So document C is the termination memo. This was written by the terminator, the guy who fired your guy. So it's created by management prior to termination. And I'll read some of it that's highlighted. It's a memo. It's all typewritten. It's not handwritten. You don't know if there's a real signature on it. It's dated 5/18/2012. Remember, your guy is fired June 14th, 2012. So about a month before your guy was fired, someone wrote this document. A month is a long time, maybe, you know, if they think there's a guy's job on the line. But remember, this guy got fired out of nowhere. So he didn't know it was coming. Neither did the immediate supervisor, but someone's writing a document that says at the top where it's highlighted, cause for separation. So already a month before, in a world where you need to explain your reasoning for terminating or not terminating a disabled employee, someone's discussing separation among management without sharing it. And you see in the middle paragraph there where it's highlighted, he cannot lift over 30 pounds. Johnny has also been told by another doctor that he cannot climb ladders. And then the next paragraph down, because of these restrictions, Johnny is unable to perform the essential functions of his job. And lastly, recommendation to terminate Johnny's employment. So this is pretty interesting stuff. After you've spoken with and interviewed Johnny's immediate supervisor who issued that declaration, after you've taken the formal deposition of the doctor who said he didn't give no ladder restriction at all. Like, he was free to climb ladders all day long. So where's this guy getting his information from? This is really interesting. And the timing. This guy got fired out of nowhere, and this was a month before. So we really need to look at this, but let's see how it works out. So your evidence, again, the recommendation to terminate was about a month before the actual termination. He could have talked to Johnny himself and say, hey, I actually had to write this memo today because I don't think you can do your job, Johnny. Is that true? And you can tell that whether or not, whatever the case, whatever the basis, there's at least a perceived inability that Johnny cannot lift more than 30 pounds based off this memo, and that the employers think this is a big problem. But they are mistaken about important facts. Remember, he said, you know, he's been told by a doctor that he can't climb ladders, and did you specifically tell him that you cannot climb ladders? The doctor says under oath, no. And so you really go into this credibility issue right here where, you know, is this memo really credible? This document that it's not under oath, it's not anything. Well, you learn that the terminator, the guy who wrote this, rarely saw the plaintiff himself. He's not a percipient witness. He's like a guy who's writing history about an event he never saw. Maybe that's okay sometimes, but if you have other more credible evidence, just like in history, that's probably going to be looked at as the best source, the most reliable document to establish what happened. And this document contains two provably false statements, at least to you, ladders, and that he can't perform this lifting restriction. Again, he said he could do his job till the day he was fired. The immediate supervisor says he's good to go. So as a historian, now your antennae are going kind of both ways right now, going, what's going on with the history here? So the next document is the Terminator's deposition. So it's his turn. What really happened? And again, it's a compelled investigation under oath with another attorney for Acme Co. right there. And so he's asked, going to the very top where it's not highlighted, it says, was it the policy at Acme for employees to help other employees when needed? For example, requesting help to lift a heavy item? And the Terminator says, yeah, could be. So that's pretty good. And then you ask him again, or it's highlighted, was that encouraged that employees would help other employees to help at Acme, lift heavy items? Answer, yes. And then question to the Terminator, to your knowledge, did you ever hear about that being a problem? Where an employee would ask another employee for help in lifting a heavy item? No, not to my knowledge. And this is the Terminator who just wrote, he can't lift over 30 pounds. That's such a big problem, he's got to be fired. But here he's saying that there's a policy where you can get help lifting whenever you want it. No one's ever reported it as being a problem at Acme Co. It's the policy. So what's the guy saying now? When, really, when you're talking to the guy in person, what does he say? This is what he says. So this is clearly, in terms of credibility, there's a very strong argument that memo's got some big credibility problems. And maybe this deposition should be given more weight by the jury. Here's the breakdown of that last document. It's the same guy who wrote the termination memo on 5/18 a month before, who said he can't lift. And you learn from this deposition that there's a policy. So someone wrote a rule that's running Acme Co. that says we want to encourage getting help lifting. Obviously, there's a good reason, because you don't want people to throw out their backs and get hurt. So there's a policy there to receive assistance lifting heavy things. And that this policy has never been a problem, according to the guy who fired this guy. So is the Terminator credible? Well, you learn when you talk to him that he's actually a nice guy. Uh-oh, what happened? Did this guy just make an innocent mistake? What's going on? So, before this day where you take his deposition and you see him, you think he's this big bad monster. It turns out that's not the case at all. He's a regular guy. So, that might be a problem for your case, but you've really got to look at it like a historian objectively. Like, did that matter in this case? Did that have a bearing on how this happened? Was his duty as an employee for management, was that really the driving thing more than him being a nice guy in person? And, you got to bring that into account, even as if you're proving something in history and you have an idea in your mind where you want to take it. If things like the historical documents and the books you're reading are pointing in a specific direction, you want to go there, and someone's pulling you off, you have to look and see what they're saying. You can't ignore that. You got to take it in and get the facts, just like the law, just like history. So this next document is it is still on the Terminator's deposition. Remember, he's a nice guy. So what does he say? Well, he's asked at the very, very top, where it's not highlighted, why didn't you elect to actually go around with Johnny after May 15th? Remember, that memo was written May 18th, to see whether or not he could actually perform his job duties with the restrictions that were given by the doctor. An objection from opposing counsel. Then he does answer, the witness, because the job he was doing, again, required his physical work, and within those restrictions were going to be difficult for him to do that. Didn't answer the question, right? He was asked, why didn't you go around and watch the guy? And he doesn't answer your question. Credibility's coming in. And then it's asked again, okay, but you came to that conclusion that without actually going around and observing him doing the job duties? Answer, yes. So he made all these conclusions. He never saw your guy. Unlike Johnny, who says, I was doing my job just fine. Unlike Mr. Supervisor, who said, there's no problem at all with Johnny. I have no idea why he got fired. This terminator says, actually, I made that decision. I never saw the guy. That's really going to factor in on your credibility. So your evidence, the terminator did not take the time to even watch this guy. Remember, you have to prove, going back to the law that we're using, that there's actually this good faith interactive process, this discussion to go back and forth and be transparent about whether a disabled employee can actually do their job with this modification. And so from this, you can see that he didn't really do that. He didn't watch the guy do his job, even though he still recommended that he was fired. That's a problem for them. Your evidence, the terminator didn't care about an investigation. Like, you know, he made this decision not to go around and watch the guy, and it makes it seem like he didn't even care. Like, he just kind of wrote this memo, and then he's done, and then he's fired, and that's it. But you really need to do more than that. And so this is really, okay, what's going on with history now? So we're wrapping up with our evidence. This is all the evidence we're going to be weighing. Remember our legal context, disability discrimination. It's illegal to terminate an employee because of a health condition if that employee could perform the essential functions of their job with a reasonable accommodation. Now let's go through the evidence. The immediate supervisor. The plaintiff was doing a good job. And you have the plaintiff himself, I was doing a good job. You have the plaintiff's doctor. There was never a ladder restriction. And you have the terminator. He could get help lifting whenever he wanted it. And so applied those historical facts, applied to the law, that sounds like an okay case so far. And remember our other legal context, employers may only terminate disabled employees after a transparent investigation of all the facts called an interactive process. So it's a back and forth, good faith discussion about whether they can do their job. And our evidence, our history shows that the terminator never spoke to the employee or the supervisor. That history applied to the law isn't so good for Acme Co. right now. It's pretty good for your case. The terminator got important facts wrong. He should have spent the time in that month before the termination when that memo was written really digging and actually take the time to watch, and he didn't do it. He had a month to investigate further, and he just didn't. And the terminator failed to observe the employee himself, even though he's making this important decision about his life, and this is the law. It didn't happen, but he's a nice guy still. So, our verdict. Just like you are using archaeology, a fraction of one document that's tattered and you can only read part of it, art, you know, if there's a depiction of an event that you want to learn about, you can glean and get almost a good vision about what happened in history and use that to establish, well, I think that's the case. This is my evidence. Some of it was shaky. Some of it was pretty good. This is what happened, and therefore these things occurred. You're clear about it. That's the way you reconstruct history as a historian. The same tools are used and applied in the practice of law all the time. You have primary evidence. You have secondary evidence. You're judging credibility just as you are an historian. You take all these tools with you that you get as a history major at UCSC, and you can carry them on with this investigation that you use in the law all the time. It's the same analysis. So what's our verdict? What's history good for? Well, it's good for the law. It's really good. You can apply it to everyday life too. This is a way you can approach current events. It's a way you can approach statements people make about history. If you're judging their historical paper or their premise, or you're reading a book, it's applied all the time. So that's what history is good for. Any questions out there? In the back?
What was the settlement?
Well, Johnny did prevail in that case and got a good result.
Okay, good.
I'll say that. The justice did well by Johnny because I went to UCSC and, went to Cindy's classes and really studied the historical method. We got a good result. And, really, you can't separate history from, what happened. And applying that to your case and advocating for a client and really changing someone's life, too. Any more questions? Yes.
Did they determine that his supposed injuries were because of the job he had?
Yes, they did, but that didn't really matter for a few legal reasons. It really, in the legal world that we were in, the distinction of where the particular injury occurred didn't matter. It was just the analysis I gave up there that if they could do their job and Johnny could keep working with an accommodation, then he couldn't be fired legally. That's where he kept it. Any more questions? That's all. Thank you so much.